It was noted in the pre-sentence investigation report that he said if he had known this was going to happen, he wouldn't have done it. Something to that effect. Or he wouldn't have participated.
He was 16 years old when he told a probation officer that if he had known this was going to happen, he wouldn't have done it. He said something to that effect. A judge would read that sentence back to him in open court, moments before deciding how much of his life he would spend behind bars. That single sentence, a boy's quiet admission that he hadn't understood the weight of what he was carrying, became the exact fact the court used to conclude the opposite, that he had understood, that he simply chose not to stop. This is the moment the record speaks for itself. No one raised their voice. No one needed to. The defendant's name was Stein, 16 years old at the time of the offense, a boy who had lost his father, and in the vacuum that followed, had assumed a role no 16-year-old is built to carry: provider, protector, the one who steps up when a family is short a parent. That is not speculation. That is testimony the court itself credited. And it is precisely that testimony the court would later turn against him, transforming a story of grief into a story of premature maturity, and premature maturity into a legal argument for adult consequences.
Understand the charge before you understand the man. Stein stood convicted of first-degree murder, along with 3 counts of attempted robbery, each one charged with actual possession of a firearm. In Florida, actual possession of a firearm is not a technicality. It is a sentencing trigger. It means the state proved the defendant physically had the weapon in hand, not merely nearby, not merely aware of it. And when a firearm is actually possessed during certain violent felonies, Florida law imposes what is called a minimum mandatory sentence, a floor beneath which no judge, however sympathetic, however persuaded by circumstance, is legally permitted to go. Even before the judge said a single word about who Stein was as a person, the statute had already decided part of his fate. The state and the defense spent the opening minutes of this hearing arguing not about guilt, that had already been decided by a jury, but about a number: 10 years or 25. The court itself misspoke the figure aloud, corrected mid-sentence, landed on 10.
For the record, the state's present, defense counsel, defendant are present. I have reviewed the statute that was last mentioned regarding the minimum mandatory sentence. It does appear from my reading of the statute, 775.087, subsection 1, 2A, maybe. Let me get back to it. It does indicate a 10-year minimum mandatory sentence for the attempted robbery with a firearm on each of those. So I believe defense counsel is correct.
It is a small moment. It is also a useful one. Even the person about to decide a boy's future needed a second to get the statute right. Keep that in mind the next time you assume the law is applied with mechanical certainty. It is applied by people, reading statutes out loud, sometimes getting the number wrong the first time. Before we go further, ask yourself this, because the answer will not be obvious yet. How do you sentence a 16-year-old to what may be a life sentence when the law itself requires the court to weigh his youth as a mitigating factor, and yet requires in the same breath that the court treat the crime with the full gravity of what it actually was? That tension is the entire architecture of what follows. Florida Statute 921.1401 exists because the United States Supreme Court ruled that children cannot simply be sentenced like adults, that youth itself must be weighed, deliberately and on the record, before a court imposes a sentence that amounts to life. The statute lists 10 factors.
01, subsection 2, A through J are the following circumstances the court must consider. It says, in determining whether life imprisonment or a term of years equal to life imprisonment is an appropriate sentence, the court should consider factors relevant to the offense and the defendant's youth and attendant circumstances, including but not limited to, and I'll go through each of these factors.
The judge in this case did not summarize them. She read every one, in order, out loud, and applied each to the specific facts of Stein's life. That is not a formality. That is a court building a record, brick by brick, knowing that record may one day be reviewed by someone else. The first factor is the nature of the offense itself. The court's language here was deliberately restrained, violent in nature, terrorizing to the victims. Two young women walking home from a movie. They had done nothing to provoke what happened to them. The court noted, almost as an aside, that this was the kind of crime that changes what a community believes is possible on its own streets. Parents who once let their children walk home at night reconsidering. That is not sensationalism. That is the court naming, precisely, what a violent crime actually costs, beyond the victims themselves. Then came the factor that should trouble anyone who has ever assumed adolescence is a single uniform condition: the defendant's maturity. The court found that Stein, despite being 16, had developed a level of independence beyond his years, driving a car, provided with a vehicle, carrying responsibility inside his household after his father's death.
Subsection C, the defendant's age, maturity, intellectual capacity, and mental and emotional health at the time of the offense. The defendant was 16 years old, had, based on the evidence and testimony, an apparent knowledge and comfort with firearms, that he knew what they were, he knew what they did, and was not something that was foreign to him in possessing or using a firearm. His age, even though 16, his maturity, based on evidence, was that he drove a car, was provided a vehicle, he was capable of doing many things that 16-year-olds can do, and maybe even a little bit more, because he had developed a sense of independence after his father had passed.
On its face, this sounds like praise. In this courtroom, it became the opposite. The same grief that might have earned him sympathy became instead the evidence used to argue he understood consequences better than most boys his age. Sit with that for a moment, because it is worth asking directly: should a childhood shaped by loss and premature responsibility be treated as a mitigating factor? Or can a court reasonably use that same history as proof the defendant knew exactly what he was doing? The statute assumes these are separate questions. This hearing suggests they may not always be. The court moved next to family and community, and here the record offered something rarer than absence. Stein had a supportive family, responsible adults, brothers who showed up. The court was careful, almost pointed, in noting that many families face tragedy and manage, together, to remain productive, intact, law-abiding. The implication sat quietly beneath the language, never stated outright, exactly as this channel prefers it. The resources were there. The support was there. What happened? Happened anyway. And then, the factor that will likely generate the most disagreement among anyone who has ever sat where you are sitting now, watching this unfold: immaturity, impetuosity, the failure, common to adolescence, to fully appreciate risk and consequence. The court acknowledged Stein had prior contact with law enforcement, a juvenile charge, burglary of a conveyance, and used that single prior contact to conclude he understood, structurally, that laws exist and that breaking them carries consequences.
Subsection E, the effect, if any, of immaturity, impetuosity, or failure to appreciate risks and consequences on the defendant's participation in the offense. Reviewing the testimony in trial and statements made today as well, the defendant really was more mature in some ways because of the loss of his father and his obligation that he seemed to express to step up and help provide in the family and take care of siblings and do things that many people at 16 don't have to do. And so he developed that ability and showed that. And so his level of maturity actually was probably more than that of a 16-year-old. As far as his failure to appreciate risks and consequences on the defendant's participation in the offense, it is shown that he did have prior interaction with law enforcement as a juvenile with the burglary of a conveyance. So he understood that there were rules, laws, and then if you broke them, there were consequences. So he was not unaware of that.
One juvenile offense, doing an extraordinary amount of legal work. Ask yourself whether a single prior brush with law enforcement, at an age when the brain itself is still assembling its capacity for judgment, should be sufficient to establish that a boy fully grasped what he was walking into on the night 3 people ended up robbed and 1 ended up dead. The statute permits the court to draw that inference. Whether it should is a different question, and it is one you are entitled to have an opinion about. Here is where the case turns, and where the calm of this courtroom becomes its most dangerous quality. Dangerous not because anything improper occurred, but because precision, applied without mercy, can look identical to fairness while producing an outcome that leaves almost no room to breathe. The court turned to the extent of Stein's participation, and the evidence here was not ambiguous. Video surveillance showed the vehicle he was driving past the victims, not once, more than once. He had the opportunity, the court noted, to simply not come back. He came back. The defense argued influence, that Stein had been pressured by others in the vehicle, that peer pressure played some role in what followed. The court did not dismiss this outright. It acknowledged there may have been some pressure. And then it delivered the line that will likely define this hearing for anyone who watches it closely. He had opportunities to get away from that pressure, to avoid this incident, and to prevent it from happening. Pressure explains. It does not excuse.
Come back. Now, I understand the defense's argument that he was influenced by those in the vehicle, but he drove that vehicle. He brought that evil to the victims, and he had the choice to do that on more than one occasion, or to avoid that. The effect, so subsection G, the effect of, if any, of familial pressure or peer pressure on the defendant's actions. The court notes there may have been some peer pressure on the defendant. However, again, he had opportunities to get away from that pressure, to avoid this incident and prevent it from happening.
That is the distinction this court drew, and it is a distinction worth remembering the next time you hear a defense built on the idea that someone else made him do it. We are now at the point in this hearing where the court's language stops being about what happened and starts being about what it means. And this is where the best part of the record is still ahead of us, because everything that came before was the court establishing the facts. What comes next is the court deciding what those facts are worth. The final factors folded into one another with a kind of grim efficiency. Limited prior criminal history, true, on paper, technically true.
Age, the nature and extent of the defendant's prior criminal history, very limited. We have the one offense that was noted as juvenile for burglary of a conveyance. J, the effect, if any, of characteristics attributable to the defendant's youth on the defendant's judgment. He was 16 years old at the date of this offense. He had a prior experience with law enforcement. He understood that there were laws and there were consequences of violating laws. He understood and appreciated the nature and the use of firearms.
The effect of youth on judgment. And here the court arrived at the sentence that started this video. Stein had told the pre-sentence investigator that if he had known this was going to happen, he wouldn't have done it.
The court did not read this as evidence of a boy overwhelmed by circumstances beyond his comprehension. The court read it as confirmation that warning signs existed the entire night: a planned car burglary, a firearm brought along and captured on video, a firearm Stein himself was shown providing to his co-defendant, and that a person who hands someone else a gun before committing a crime has already demonstrated an understanding that violence was, at minimum, a possibility he was willing to accept. It wasn't something that came out of nowhere, the court said. There were signs all along that tragedy was probably going to happen. Then, rehabilitation, the final factor, and the only one that offered anything resembling hope. The court acknowledged Stein's supportive family, his stated remorse, his expressed desire to become a productive member of society. The court found that possibility real, and then delivered the sentence that made that possibility, for the moment, almost entirely theoretical. Life imprisonment with a 15-year review.
So it is the considered judgment and sentence of this court that Mr. Stein shall be sentenced to a term of life imprisonment in the Florida Department of Corrections with a 15-year review. So we will have that opportunity to make that assertion in terms of rehabilitation after 15 years. And like I said, your possibility of being rehabilitated will be up to you. And that is for count 1.
Slow down here, because this is the part of the record where the weight actually lands. A 15-year review does not mean release. It means that after 15 years, Stein earns the right to ask a court whether he has changed enough to be considered for release. Not a guarantee, a conversation. Whether he gets that conversation, the court said plainly, will be up to him. That was count 1. Then came counts 2, 3, and 4. 3 separate charges of
Count 3, attempted robbery, actual possession of a firearm, a second-degree felony. The jury having found you guilty of that count and the court previously adjudicating you guilty, you will be sentenced to 15 years in the Florida Department of Corrections with a 10-year minimum mandatory as part of that sentence. That count will be consecutive to count 2. And in count 4, attempted robbery, actual possession of a firearm, a second-degree felony. The jury finding you guilty of that count and the court previously adjudicating you guilty on that count, your sentence will be 15 years in the Florida Department of Corrections with a 10-year minimum mandatory. That sentence will be consecutive to count 3.
Defense counsel did the arithmetic out loud, in real time, in open court. Even if the court finds him rehabilitated at the 15-year mark, he still owes 45 more years after that. Read that again, slowly. 15 years to earn the conversation about whether he has changed. 45 more years waiting, regardless of the answer. The defense asked the court to reconsider, to make those sentences run concurrently instead, so that the promise embedded in the 15-year review might actually mean something within a lifetime. The court's response was brief and final. I've considered it. The sentence the court has imposed is what I believe is appropriate under these circumstances. I will leave it the way I've ordered it.
So I will leave it the way I've ordered it. I will, let's see. I will tell you, Mr. Stein, you have 30 days from today to file an appeal. If you can't afford an attorney for an appeal, one will be appointed for you, and you will get fingerprinted and...
No raised voice, no lecture, just the calm, immovable weight of a decision already made, delivered in the same measured tone the court had used for every statutory factor that came before it. That is the entire identity of this hearing in a single moment. A courtroom where nothing was performed, and everything still landed with the full force of law. The hearing closed the way these hearings almost always do, quietly, administratively, almost anticlimactically after everything that preceded it. 30 days to file an appeal, a public defender if he cannot afford one, fingerprinting, a few minutes with his family,
no physical contact permitted in the courtroom. Then the court addressed one final, almost bureaucratic detail: whether Stein qualified as indigent for the purposes of that appeal. The court found that he did.